I'm joined by Mark Dubbery, a barrister and mediator, Pub Court Chambers. Mark, somebody wants to challenge a will. They are feeling they've been treated unjustly or unfairly after a loved one's died. And what will happen if there is no will?
If there's no will, then an application has to be made for what's called a grant of letters of administration. And that allows the administrator to do what an executor would do when they'd been appointed by a will. They step in and they distribute the estate, and they do so in accordance with the rules of intestacy. And the rules of intestacy set out the priority by which that estate is distributed. So spouses have the first consideration, and children, siblings, and out among more remote family members.
So the rules of intestacy may not see the wishes of the deceased come to effect, or maybe against what the surviving relatives believe they would have wanted.
Very often, particularly in cases where somebody's not married but has a long-term partner, because the rules of intestacy make no provision for partners at all. Also, one often finds that the rules of intestacy don't necessarily reflect the cultural or religious expectations in many cases.
Thank you very much, Mark. Thank you. Question number 9. I'm joined by Mark Dubbery, barrister at Pub Court Chambers. Mark, somebody wishes to challenge a will. They feel they've been treated unfairly and justly after the death of a loved one. Will they have to go to court to contest a will?
No, in fact, it's only in a very small minority of cases that people actually end up having to go to a court building. Disputes should be dealt with firstly in correspondence. The civil procedure rules by which court proceedings are governed say that litigation should always be a last resort. So first, parties should try and enter into negotiations in writing. If that doesn't succeed, then what usually happens is that they proceed to what's called a mediation, where they attend, often with legal representatives, and then a mediator who's an expert in resolving these disputes through consensus will spend the day shuttling backwards and forwards and searching for any possible avenue of compromise. So it's even when cases are issued at court, my experience is that a significant majority of them, I think statistically it's more than 80%, get settled before a trial takes place.
That's great, because the cost of going to court is huge. It's very expensive to go to trial.
In very many cases, the parties' combined costs of going to trial will be as much as or even more than the amount of the estate that's being disputed.
That's tremendous. Thank you very much. Thank you.